I thank the chairman. Mr. Chairman, proposals to split up the Ninth Circuit Court of Appeals have been floated since at least 1941. What was a bad idea at the time of Pearl Harbor remains a bad idea today. Proponents of splitting up the Ninth Circuit generally mask their arguments and concerns over its size and the supposed detrimental effect this has on judicial efficiency and on the consistency of its rulings. They say that it covers too much geographical distance and too large a population to be effective. They argue that because it is so large, there is administrative waste, there are procedural delays, and the judges are unable to work together to produce a consistent and rational jurisprudence. However, the facts say otherwise. It is true that the Ninth Circuit is the largest of the 11 regional circuit courts of appeal in terms of physical area, of population covered, and of caseload. With a district that includes Alaska, Hawaii, and the territories of Guam and the Northern Mariana Islands, it's no surprise that judges must occasionally travel great distances to serve the entire circuit. But we have things called jet planes and email that make it possible to minimize the disruption that any physical distance may cause. Indeed, that disruption is less today than it was in 1941. And with California as the anchor state in the circuit, it is unavoidable that it will cover a large population. Unless you were to split the state in half, which would be disastrous from the point of view of judicial coherence, a large circuit is just a fact of life. But there is simply no evidence that the Ninth Circuit size has impeded its ability to administer justice to the people within its jurisdiction. To the extent that there is a somewhat higher backlog of pending cases in the Ninth Circuit compared to other circuits, more resources can be devoted to resolving those issues. Indeed, just yesterday, the Judicial Conference recommended adding an additional 5 judges to the Ninth Circuit, which would certainly reduce the workload per judge. And technology is being deployed in a variety of ways that help improve administrative efficiency. There is also no evidence to support the frequently made claim that the Ninth Circuit is a renegade court with wild and unpredictable rulings. Even the often cited statistic that the Ninth Circuit is allegedly the most reverse circuit at the Supreme Court is wildly misleading. Given the very small sample size, since so few cases ever reach the Supreme Court, it is hard to conclude much from the sometimes modestly higher rate of reversal that the Ninth Circuit faces by the most conservative Supreme Court in many generations. Indeed, the worst number cited by critics is 2.5 reversals per 1,000 decisions. What this debate is really all about is that conservatives do not like the more liberal rulings that occasionally emerge from the Ninth Circuit. They believe they can manufacture a new circuit that will produce more conservative results. That is a very different and a more dangerous matter. Like clockwork, we see proposals to split up the Ninth Circuit whenever it delivers a controversial decision with which conservatives disagree. Whether it is ruling that the Pledge of Allegiance should not include the words "under God," overturning restrictions on abortion or gay rights, or most recently its unanimous decision to uphold a temporary stay on President Trump's unconstitutional Muslim and refugee ban, the Ninth Circuit has long been in the sights of Republican politicians. Just last night, President Trump said at his campaign rally, "People are screaming, break up the Ninth Circuit." This is a quote, "People are screaming, break up the Ninth Circuit. And I'll tell you what, that Ninth Circuit you have to see. Take a look at how many times they've been overturned with their terrible decisions," unquote. But to manipulate the federal courts in order to achieve the political ends you seek is highly inappropriate. Just as there is a nationwide movement to end legislative gerrymandering, we should resist this form of judicial gerrymandering as well. Proponents of splitting up the Ninth Circuit will present a vast array of reasons why it is too large and must be broken up. But none of their arguments withstand scrutiny. And the proposals they have advanced to solve the alleged harms they cite would not actually achieve the results they say they want. Any proposed 12th Circuit would still cover a significant distance and leave in place a large Ninth Circuit based in California, all while introducing uncertainty into the law at great taxpayer expense. While I believe that splitting up the Ninth Circuit would be both unnecessary and unwise, I appreciate having the opportunity to hear from all our distinguished witnesses on this issue. I would note that all 3 of the judges appearing today, like a majority of their colleagues on the Ninth Circuit, oppose such a split, as does the American Bar Association and numerous other practitioners and experts who have studied this issue in great depth. I look forward to the judges' testimony and to the testimony of our other witnesses, and I yield back the balance of my time.